Welcome to Dorsey & Whitney's Bank Council Roundtable on Financial Service Regulation under the Biden administration. What will change? What will remain the same? I'd like to introduce Nick Vlietstra, a partner and co-chair of Dorsey's Financial Services Regulatory Group. Take it away, Nick.
John, good afternoon, everyone. This is Nick Vlietstra, and welcome to Dorsey & Whitney's March session of the Bank Council Roundtable. Thank you very much for joining us. We've planned a 60-minute presentation on financial service regulation under the Biden administration and what will change and what will remain the same. We have two speakers today, both from our banking and financial institutions industry group. They are Joe Liniak and Tom Scanlon. By way of introduction, Joe Liniak is a partner in the firm's finance and restructuring practice and is a nationally known bank regulatory lawyer. Joe practices out of the firm's Washington, D.C. and Southern California offices. Tom Scanlon is also a partner in the firm's finance and restructuring practice, focusing on financial services regulation. Tom, too, is from our Washington, D.C. office. More detailed bios of our speakers are in your materials, as is their contact information. I also have a couple of housekeeping items to go over before we get started. First, please remember to sign in on the attendance form we've provided and return it to attendance@dorsey.com. If you are looking for your attendance sheet or for today's presentation materials, they're available for download from the webinar reminder email you received yesterday from events@dorsey.com. Second, you can use the Zoom chat function to send our speakers a question. If time permits, they will try to address those questions at the end of the presentation. If there's not time at the end of the presentation, we invite you to contact our speakers using the contact information provided in the presentation materials, or you may get in touch with your usual Dorsey relationship contact. So with that, I hand it over to Joe Liniak.
Good afternoon, everyone. What we're going to try to do today is look into our crystal ball and figure out what's going on going forward with the Biden administration. When then Vice President Biden was running for office, he had literally hundreds of supporters providing policy advice and guidance and suggestions, and we try to boil them down in a manner which makes some sense going forward to understand what is happening. And we've got the categories of new appointments and personnel, executive orders already taken or about to be taken to reverse or modify the Trump administration's approach to financial service governance, and probable reviews by each agency of recently adopted rules or interpretations, because that's what happens when the new kids of the block come on board. They take a look and say, we don't like this, we don't like that, let's change things. But then about the fact that there is a concept of business as usual in the financial services sphere, we want to touch upon that briefly, and then give you a few concluding observations of what we think is about to happen, with an overriding question: will there be significant changes to bank examination and supervision on a go-forward basis? To start it off, I'd like to turn the microphone over to my partner, Tom Scanlon, who many of you may know was part of the Obama administration's team that wrote Dodd-Frank, worked with many of the personalities we're going to be talking about today, and I think brings a very interesting perspective of inside the Beltway knowledge of how these things took shape and what may be happening going forward. So I'll turn this now over to Tom.
Thank you, Joe. Good afternoon, everyone, and we appreciate you joining us this afternoon for this look, as Joe said, into the crystal ball of how the Biden administration and the banking agencies will shape regulatory policy for banks and other financial institutions. And one of the themes that we have is that policy is actually the personnel who now will take over the administration and lead the agencies. We start with the observation that the Trump administration had appointed political types into positions to oversee the ranks of the career civil service. But more importantly, the ranks of those experienced civil service personnel already had been depleted. And that shouldn't be of too much of a surprise. During the last several weeks, even prior to the events of January 6th, lots of news stories have been circulated that a lot of the politicals in the Trump administration are not getting jobs, that headhunters and other potential entities are simply not giving those individuals a shot at being hired. And looking back in 2017, everyone in Washington knew that if going to work with Trump was a relevant option, that going into the administration was going to tilt the odds for that individual heavily towards a poor outcome in 2021. In 2017, there was simply no mystery about what could happen to the professional trajectory of a person for working for a real estate developer who loves bankruptcy events. And moreover, after the first year or two of the Trump administration, the turnover for senior officials was at rates that we had never seen before in previous administrations. The practical result of that is that fewer and fewer professionals entered the ranks of the banking agencies as well as the other federal agencies. And so the ranks right now are significantly depleted from prior administrations, including in the Bush years. What we have now, to the next slide, Joe, is a set of new appointees, all of whom at the most senior levels has significant experience in federal service with the financial regulatory agencies. If we were to start at the top with Secretary Yellen, and for me, I need to get out of the habit of referring to her as Chair Yellen. She, of course, is well known to everyone as the former chair of the Federal Reserve and a longstanding official for the Federal Reserve Bank. The other person who I want to draw attention to for the Department of the Treasury is Lori Schaefer, who, as an aside, I'll just relate to everyone, was my boss at the Department of the Treasury for several years. Lori served most recently as Deputy General Counsel to the Federal Reserve Board in the legal division and was the principal attorney supervising the developments for the Volcker Rule and many of the important supervisory matters from the board's legal division. And prior to her service at the board, Lori was Assistant General Counsel for Banking and Finance. And I'll highlight why her experience then and now is important to assessing the trajectory of the Biden administration. Next, of course, we have Mr. Chopra and Mr. Barr and Mr. Gensler. Mr. Chopra and Mr. Gensler already have been nominated by the Biden administration to lead federal agencies. And in the case of Rohit Chopra, to be the director of the Bureau, and in the case of Gary Gensler, to be the chair of the Security Exchange Commission. And what's important to appreciate, I believe, is that the range of experience for each of these officials is quite deep. Rohit Chopra has served as a commissioner for the Federal Trade Commission, and Gary Gensler previously was the chair of the Commodity Futures Trading Commission. For Mr. Chopra, that experience in a multi-member board, and particularly with the issues that cut across a lot of harms to consumers, will be instrumental towards shaping the senior staff at the Consumer Financial Protection Bureau. And not to be overlooked, of course, is the direct line that Senator Warren has to the high echelons of the Bureau. In the case of Gary Gensler, in my estimation, the most important asset that he would bring to the SEC is that he's been the chair of a multi-member board at the CFTC during a period of pretty high tension when rules were being adopted to implement Title VII of the Dodd-Frank Act. The other official that we've highlighted here for all of us is the potential appointment of Michael Barr. That has not yet been settled upon, but if Michael Barr were to be appointed and confirmed to be controller of the currency, he would represent yet another experienced hand in the Biden administration, since Michael has served already as Assistant Secretary of the Treasury for financial institutions and was one of the principal attorneys guiding the day-to-day development of the drafting and implementation of the Dodd-Frank Act. I think we can go to the next slide.
Well, in the area of financial services regulation, what did the Trump administration do? One of the things they did very early on, within, I believe, the first 2 weeks of the Trump administration, is that they issued an executive order, 13992. It directed the Treasury to analyze and focus on economic adjustments to Dodd-Frank in the financial services industry. And they used the buzz line of core principles to be used and to set an agenda for the marketplace to understand. And they issued several reports dealing with banks and credit unions, capital markets, non-banks, asset management and insurance. They were, frankly, excellent, very, very well done and documented, and, if you will, set the agenda for financial services going forward. I think it's kind of important that maybe we just stop for a moment and think about the overriding themes of how the financial services would be regulated by looking at some of the themes inherent in the report on banks and credit unions. And that include improving regulatory efficiency and effectiveness, reducing regulatory burden by decreasing unnecessary complexity, tailoring the regulatory approach based upon size and complexity. And I think taking a step back as well is useful in that Dodd-Frank was adopted in July of 2010, but due to the view on the part of the liberal wing of the Democratic Party, no action could be taken to amend probably the 10% of Dodd-Frank that were problematic. And that's not unusual when you have major financial service reform legislation. You usually mess up a percentage of it. But nothing could happen because of the fact that the liberal wing of the Democratic Party was concerned that due to the voting capability in the Senate, they would emasculate the CFPB. And therefore, nothing happened for about 8 years. And we will get into that in a little bit in what happened in 2018. On the consumer side, mentioning the CFPB, the acting director appointed by President Trump was Director Mulvaney, followed by Kathy Kraninger, and they refocused the emphasis on enforcement at the CFPB from large banks to small company activities. We were all complaining about regulation by enforcement. And one of the problems with large banks is that they are not very nimble, cannot fight back as much, have got a lot of reputational risk about fighting back. And that was effectively abandoned. And they went towards enforcement and examination and supervision of small companies, many of which were non-banks. Civil money penalties were also reduced to almost to a zero number. Again, highly unusual, whereas during the reign of King Cordray, billions of dollars were assessed against large banks and others for civil money penalties based upon the CFPB's new authority. And the CFPB during the Trump administration issued several consumer regulations that were heavily criticized and are being continuously criticized by consumer advocates. Among other things that happened, the CFPB refused to supervise banks and non-bank creditors for compliance with the Military Lending Act. That has now effectively been reversed, and you will see on a go-forward basis a new emphasis on protecting our military personnel. One of the other things that happened, which I think is an important focus of this discussion, as a result of the inclusive communities decision by the Supreme Court, the Trump administration took a very, very narrow reading of the approval by the Supreme Court of disparate impact and use that very, I think, narrow or conservative viewpoint to significantly reduce the effectiveness of disparate impact as a means by which discrimination in housing and lending could be proven. So again, we're going to come back to this theme, but I think it's something that everyone really needs to understand, that this is something which is going to change. Let's first now go to, and I'm going to turn it back to Tom, as how will the Biden administration, what tools will they have to change things?
Thanks, Joe. Well, the Biden administration will exploit all of the available tools for adopting new policies and adopting new rules. Executive orders, adoption of new rules subject to the procedures of the notice and comment process of the Administrative Procedure Act, and of course, legislation. And to think back to one of our principal themes here this afternoon, that policy really is personnel, we should note that the senior officials that currently are in line and other officials that the Biden administration likely will appoint and place into the banking agencies will have exactly the opposite effect of the officials that serve for the Trump administration. We have already seen the appointment of senior officials who have demonstrated commitments to serving for several years or even throughout the entire term of the Biden presidency. And consequently, for other officials in the agency and very senior staff, managers, for example, the career path will be much more predictable for an individual to come into the administration or to go into a banking agency. Furthermore, the experience from a day-to-day perspective for any one of those professionals would be that there's going to be low, if any, risk that some tweet on Saturday morning is going to completely undercut 2 or 3 months of that person's life's work. And what that means then is that we should be prepared for executive orders to be fully implemented through policies and white papers. We should expect for notice of proposed rulemaking to take on fairly sophisticated subjects and to conduct the cost-benefit analysis in a way that smartly gets to where the officials of the agency wish to take the agency. And that's all going to be made much more effective, in our estimation, from the experiences that senior officials have with working with the agencies. There should be a much higher degree of collaboration because the senior officials will realize that each one of them likely is going to be around for a few years and will have to be grappled with and accommodated and worked with from time to time. Finally, the senior officials and the senior staff at the agencies, particularly in the Department of the Treasury, have deep experience working with the committees in Congress and with legislation. And we should see then a fairly coordinated approach between the Biden administration and its wish list for adopting new laws and committees in Congress for moving those proposed bills, actual legislative text through the committee process and onto the full floor of each house of Congress. Naturally, in a bicameral legislature of ours, and even with the Senate in its position right now, enacting new laws for financial services might appear to be remote. But the important point from this early stage is to appreciate that if those legislative proposals do come to light, then the personnel on the premises actually can get that done.
Let's talk about what the Biden administration did in the afternoon of January 20th in terms of executive orders that affect financial services. Well, the first thing they did is they threw out the baby with the bathwater on a lot of areas, and you can see here several of the executive orders which were revoked. There's some of them, though, I think evidence a theme that, again, we're going to be comparing it to where we're about to go, I believe, with the Biden administration. Executive Order 13771, reducing regulation and controlling. This got quite a bit of play in the press the so-called 2-for-1 rule, where if an agency was going to be issuing a new regulation, you had to get rid of 2 of them. Now, it never really worked out that way, because getting rid of another regulation, what does that really mean? And by the way, these executive orders are rarely more than 3 pages long. They're really themes that folks such as that OMB and major agencies are supposed to consider in terms of their view of taking action. But in importance, when they had to do this, they had to do a budgetary analysis that would be 0 aggregate additional cost to regulated entities. Enforcing the regulatory agenda, likewise, creation of task forces to internally at agencies, applying a cost-benefit analysis and figuring out whether or not we can do more with less. Two executive orders promoting the law, the rule of law through improved agency guidance documents, and promoting the rule of law through transparency and fairness in civil administrative enforcement and adjudication. This is something that has bothered banks for a long, long time. And in fact, as a result, several of the banking agencies have issued regulations that effectively have said, or that we are not going to do enforcement if we are merely issuing guidance, because guidance is not the law, guidance is not a statute, guidance is merely that guidance and cannot be used as the basis for enforcement. That is now out the window. But I thought it might be useful to, in terms of the way that the complaints that were raised at that point, in terms of being ambushed by the government, in terms of an administrative decision that no one knew about. And you may be aware of the PHH mortgage company enforcement case, where the CFPB abracadabra came up with a bizarre interpretation of Section 8B of RESPA in a manner which basically eliminated that exception from the requirements, from the permissibility of RESPA, and imposed a multi-million-dollar penalty on PHH, which was, as a practical matter, a regulatory ambush. At the end of the day, after litigating the issue, unfortunately, PHH had to sell itself and to cease business, which is an admonition about the fact that don't go fighting the federal government. It can be really difficult in that regard. Eventually, the issue came up on the constitutionality of the CFPB, and it went to the Supreme Court in the Sheila Law decision, in which the Supreme Court held that 5-person commissions under the Humphrey executor's decision are valid. Written, by the way, and I think relied upon to a large extent by the Free Enterprise Fund decision made by the Chief Justice. And so again, I mean, there's a long history here about why the executive orders were important and how they really can affect policy, depending upon whether or not you have access to the Oval Office. This is something which may not seem like a lot to you, but I would say to you, this may be the most radical departure that the Biden administration may place on regulatory oversight over the next 4 years. It's an executive order on modernizing regulatory review. And we talked about some of the other, the Trump administration policies, which are effectiveness of government, cost savings, reducing regulation. But now this executive order says that Office of Management and Budget, when it reviews regulations, and when agencies have got to take a look at, under the Administrative Procedures Act, what counts, what is important, what considerations are. They've added a laundry list of things that are not necessarily addressing economic growth or minimizing regulations. There are more. Economic growth is there, but social welfare, racial justice, environmental stewardship, human dignity, equity, and the impact on future generations. If this is implemented in a way that on its face could occur, it could radically alter the result at both agency levels and OMB regarding regulations that impact all of us and how we are going to conduct our business. And finally, I note that at the same time, on January 20th, the President Biden's chief of staff issued a directive to all agencies to delay the effectiveness of all proposed regulations or final regulations not effective pending general policy review. That is now being implemented, and some of the regulations we're talking about now may be held up. And the chief of staff, Mr. Klein, indicated that the agency should give people a new 30-day window to explain why they don't like the new rules and what we can necessarily do to fix them. And then finally, again, this is going back to discrimination and fairness in the way that we conduct ourselves. On January 26th, a memorandum was issued instructing HUD to reverse what was passed during the Trump administration on disparate impact. And I think that if nothing else, I think this is important because clearly the Biden administration has been indicating that fairness and providing enforcement against discrimination is going to be a top priority. And I think that banks should make sure that they've got that they understand their obligations to engage in disparate impact analysis. And I would say that we've been doing it now for well over 10 years. And I think banks have done a very, very good job and understand what their obligations are. This may impact more folks on the housing side. It may impact more folks on the non-bank side, but this is something clearly not to ignore, because this is going to impact us, I think, to a very, very large degree, as well as the other regulation, which talks about a plethora of new standards to consider when regulations are issued. Now I'm going to turn it back over to Tom, who's going to talk about agency regulations.
Thanks, Joe. In addition to and right alongside the Biden administration's own set of objectives that Joe just outlined for us, the Biden administration and the banking agencies more specifically will need to contend with the expectations of the committees in Congress. And we've included in the materials here a slide that describes the action that the chair of the House Financial Services Committee has taken in early December to issue instructions to the incoming Biden administration on how the committee expects regulation and new laws to be adopted and enacted in the next administration. Attached to the letter is a 31-page document that contains issues and regulatory actions that span a wide range of subjects. And what's so telling about this document is two key elements to the interactions for the committees and the subcommittee of the House Financial Services Committee, as well as the banking agencies. The first is that the House Financial Services Committee simply is instructing the agencies to rescind. The 31-page document contains little or no substantive analysis about how certain policies should be improved upon, just replaced. And this really does shed light on some of the worst aspects of working with the Congress and the inner dealings with the committee, because now we're really seeing through this 31-page document government by the 24-year-olds at their worst. The outgoing chairs of the subcommittees for the House Financial Services Committee gets together with the senior staff and says, what do you got? What's all the bad stuff that has occurred during the Trump years? And the junior staff then assembles a bullet list of stuff that they simply don't like. Why they don't like it, they're not quite sure, but it goes into the list. And what's so important to appreciate about this 31-page document is that this is going to serve as a type of roadmap for the staff meetings that will occur between the House Financial Services Committee staff and the senior staff of the banking agencies, so that the staff of the committee will ask, what are you doing about this? And they're going to work through the checklist and ask, when is the agency set to rescind this policy? When is the agency set to come to hear, stand for a committee hearing to address these concerns, and so forth?
Adding a little bit to what Tom, indicated, I would say, I remind people about that old commercial about eating life cereal, and they said, "Let's give it to Mikey. He hates everything." Well, when you read over that 30-page document, they just hate everything, and that's not a good way to run a railroad, and it's certainly not a good way to make to provide guidance to folks. But that was certainly the result. What we are going to do now is go through a series of regulations that we think will clearly be addressed and point out some of the areas where groups who are critical of the adoption of regulations are now having their say, and there will probably be some opportunities for revisiting them and whether or not and how that will work its way through the system. Let's talk first about the OCC regulations, and the ones that we've identified we think are going to be revisited are the Community Reinvestment Act, the regulation reversing the Madden decision, the True Lender Rule, and the Fair Access to Financial Services. Fair Access Financial Services, by the way, has now been placed on hold. It is one of the truly strange regulations ever adopted in the banking area, and it requires an analysis of a failure by a bank to lend to specific industry segments, which impliedly means that if a oil company or maybe a big bad environmental protection agent company wanted to borrow funds, there would be an obligation to make that loan unless you were able to defend why it is you didn't want to lend to that industry segment. And it's somewhat akin to the what occurred about 40 years ago in the antitrust arena, where in order to address certain concerns that were meant to be that were thought to be anti-competitive, there are a number of per se antitrust violations that were put in place where you did not have to show market strength in order to show a violation, such as, for example, Section 106 of the Bank Holding Company Act. And the problem with the Fair Access to Financial Services is that every lending decision by a bank has a social impact. And so how do you make that determination? Who makes the determination? Is it shareholders? Is it management? Is it the determination to implement your business plan? And this particular regulation is fraught with mischief-making capability, both coming from the right and from the left, depending upon who is in charge. Turning to the CRA, it is a brand new paradigm that was adopted by the OCC. And by the way, one of the things that's important here is the OCC has got more deposits and assets than the other agencies. And so its regulation really covers almost the entire waterfront, except for smaller banks. It does several things which are important and have been complained about by a lot of consumer groups. In terms of its physical operations of the banks, it creates something known as a facility-based assessment area. But in recognition of the fact that banking is now, particularly by the millennials, walking down the road, depending upon where you are, and it really doesn't have to even be in the United States, banking can be everywhere, a deposit-based assessment area, creating new definitions about community development investments, community development loans, and community development services, which are quite different from the tests that previously were in place and still remain in place at the other agencies. What it did do, which I think will be well received by banks, is that it quantifies CRA compliance, so a bank will be able to determine what should its CRA ranking be, and we can compute it ourselves. Now, there's certainly some metrics which have got to be resolved, but I mean, the approach was certainty in order to let banks move forward, and an advanced approach for obtaining confirmation from the OCC regarding CRA qualified investments in the various categories. Now, the reason why this is controversial is that many consumer groups view the CRA as a civil rights law. And I think a better way of viewing it, and actually I was at the FDIC, unfortunately, many years ago when it was passed, it's a law addressing poverty in low and moderate income communities. And the way that it has been interpreted since the Clinton administration is that it permits anyone to raising a claim that someone is not meeting their CRA responsibilities, and they've got a merger or other important application that is taking place. The responsible banking agency freezes that application until a settlement is made with the complaining party. So that will, I think, clearly be revisited. Whether or not there will be a proposal coming out of the FDIC and the Federal Reserve Board on a compromise remains to be seen. Something very important that people need to keep their eye on is the reversal of the Madden decision and the true lender rule, which took place in June and October of this year before Brian Brooks left the OCC. On the Madden decision, Section 85 of the National Bank Act is the so-called most favored lender rule, which means that a bank, depending upon its home office, or for that matter, in some instances, its branch offices located in other states, can use the highest interest rate permitted by the usury laws of that particular state. The Madden decision, written by a judge that probably should have flunked law school, held that a purchaser could not charge the borrower the rate permissible to be charged by the national bank if a lower cap applied to the purchaser. So in other words, it effectively could kneecap national banks engaged in origination and sale of loans in the secondary market. And the OCC reversed it, but pointed out that there's two issues here. The first issue is Section 85. What does it address as to scope? And one of the things very clearly that the OCC indicated is that it is not a preemption opinion. And that's because by taking that position, it's not subject to the Barnett-Banks analysis for preemption required, which was passed under 12 U.S. Code Section 25B. And so it's an interpretation of the scope of Section 85 by adding a new paragraph to the OCC's regulation, indicating that the charging of permissible interest on a loan is not affected by the sale, assignment, or transfer of a loan by the national bank. Now, as I mentioned, there's two components of it. And the second component of it is, all right, well, you may be able to use Section 85, but are you, the national bank, the actual true lender for a particular loan? And in this case, the OCC adopted a very simple approach, and that is the national bank is the true lender if one of two things is true. One, it's named as the lender on the loan agreement, in the loan agreement, or it funds the loan. Now, this excludes, of course, warehouse funding or purchasing in the secondary market of retail installment contracts, but it is been heavily criticized by consumer groups because it permits a so-called rent-a-charter arrangement whereby some third party can rent the charter of a national bank, originate the loan using the bank's authority under Section 85. According to the OCC, however, appropriate risk management will prevent that from abuses occurring, including use of national bank underwriting, risk management, and avoiding UDAP issues. But what it does do is it fosters experimentation and innovation. I will mention the fact that, as some of you may know, this part of the rule, the true lender rule, is currently being challenged by several state attorney generals, which are focusing on Administrative Procedure Act issues. And it is probably not as clear that this is not a preemption rule which would be subject to Section 25B of the National Bank Act. So here are things which we think will be addressed in the OCC, and again, they happen very late in the tenure of Comptroller Brook. Now we're going to go over and talk about our friends at the CFPB. Tom.
Thanks, Joe. Of course, the Bureau has taken a wide range of actions in the last 4 or 5 years, and the transition between the administration for Director Cordray and Director Kraninger, of course, has resulted in several changes in policy and in the requirements under certain rules. New rules have been adopted, and we expect that the incoming director for the Bureau and the senior staff of the Bureau will take a close look at whether and to what extent the prior rules or prior policy should be reversed or revised in certain ways. I'd like to highlight a few that are appearing in our materials. The first is the Bureau's UDAP policy, which was adopted in early 2020. And the Bureau is trying to address the issue about how does a covered person or other person that's subject to the Bureau's enforcement authority or supervisory authorities appreciate when some act or practice might be leveled against the person as being unfair or abusive or both. In the estimation of the Bureau, the distinguishing key characteristics between abusive conduct and unfair conduct has not been well delineated. And so the UDAP policy is an effort to impose restraints on the agency itself to identify the facts and circumstances about a covered person's specific acts or the facts and circumstances of delivering a financial product and service that give rise to abusive conduct as opposed to unfair acts or practices. Now, of course, we see the UDAP policy appears on the list of the House Financial Services Committee as an action to rescind, but the idea that the Bureau could distinguish unfairness from abusive conduct doesn't appear to be a poor policy for administering the authorities under Section 1031 of the Consumer Financial Protection Act. And so whether and to what extent the Bureau staff really does change course might be unclear. On the next slide, we have some other items that the Bureau has adopted over the last few years. The big initiative here, of course, is the new rule for debt collection activities, Regulation F, adopted in 2 parts, and we've highlighted the citation here and the action taken in early 2021 as the second part. And we should just point out in this particular context of looking forward in the transition to the incoming Director Chopra, that the Bureau could take on more stringent standards for debt collection, particularly in the area of regulating the activities of a first-party debt collector, that is the original creditor who holds the debt. The debt collection rule that the previous director has adopted aims at implementing the requirements of the Fair Debt Collection Practices Act and applies to the third-party debt collector. Whether the substantive requirements of the rule could change, hard to say, because several important compromises were made in the debt collection rule that was adopted by the Bureau, including the strict liability on a debt collector for prohibiting a legal claim or action to collect on a time-barred debt, that the Bureau did not adopt the standard that the debt collector should know or actually knows that the debt is time-barred before bringing an action or threatening an action in court. Instead, the Bureau adopted a strict liability standard, and that in that respect, the Bureau acted in accordance with the comments submitted by many consumer advocates and state attorneys general. Also, we have, I think, a really important initiative underway, many years in the making, some people would say, and that is to adopt requirements that would implement the consumers' rights under Section 1033 of the Consumer Financial Protection Act to obtain access to financial records held by a covered person. So in the typical flow of bank records, there will be the bank providing the deposit or credit product to the consumer, and the consumer is supposed to have access to the records of the bank. So this has created an enormously complicated set of relationships between banks and other third-party so-called aggregators who are working with consumers and other developers to develop financial products that rely upon the available access to data that the original financial institution, such as the bank, already has in its systems. At this stage, in the very early stage, the Bureau has published an advance notice of proposed rulemaking. 100 comments to date have been filed on that advance notice of proposed rulemaking. And we anticipate that the Bureau's next step here in proposing a rule is going to cover several dimensions, defining the key participants, such as who is the trusted third party and what's the level of trust that that party must have to have access rights to the bank's records. Addressing the rule probably also will address the safety and soundness issues, such as whether an aggregator must satisfy the standards that the bank itself has adopted for access to its customer information systems. The Bureau's proposed rule under Section 1033 also probably will include disclosures, and hopefully, for those of us who work in this area, will provide some guidance as to the extent to which access under the rule and transmission of records from a bank to another third party could give rise to responsibilities under the Fair Credit Reporting Act. And I think with that, we'll move on to the next area.
Well, before we do that, I just wanted to go back and make a couple of quick comments on some things that we've got a little bit of time to, and that's the payday and vehicle lien rule. I think that's going to be revisited. And one of the things which is hiding behind the curtains is we mentioned the Military Lending Act and the 36% limitation on loans to military personnel. There may be a push based upon the payday lending rules to try to create a national usury limit for certain categories of loans, which will probably be the source of a great deal of consternation on the part of many different categories of lenders. You also may remember that going back in the Obama administration, the banks were encouraged not to make payday loans or short-term loans to help their customers. It would probably be very, very useful if the Biden administration revisited that policy and encouraged banks to be a source of credit as compared to what payday lending is, which can sometimes be deemed very, very unseemly. Also mention the Section 1071 of the Dodd-Frank Act, which is a provision of the Equal Credit Opportunity Act requiring that the CFPB issue regulations dealing with collecting data on women and minority-owned businesses, which has never really been implemented. But one of the things which could be of a real problem here, if it ends up seeing the light of day, is that it also would impose obligations on commercial lending, and commercial lending personnel are just not really used to the degree of data gathering which we're used to on the consumer side. So again, something which will have to be looked at. Also, to another observation which the CFPB has no answer to, and that is, if you're in a state such as California, as a matter of course, just about every asset owned by a married couple is community property, half of which is owned by women. Therefore, that would be a loan to a woman owned business. Also mentioned the qualified mortgage rule. And yesterday, the CFPB indicated the fact that they were going to be halting the rule and putting a freeze on it in order to revisit it. there are some actually very, very beneficial components of the qualified mortgage rule definition, which were adopted in December, including the ability of banks to continue to use Fannie Freddie underwriting engines for loans that do not otherwise qualify under the maximum loan amount for Freddie and Fannie. But those are things which clearly we have to look at. There is one real problem with the rule, and that is the calculation of whether or not it, under the new definition of qualified mortgage, it works for loans with a variable interest rate that changes more than once every 5 years. So we'll have to see how those things work their way through the system. A couple of miscellaneous regulations and reforms. You're probably familiar with the FSOC, and there's a couple of regulations which may be revisited. And FSOC is, one of the true failures of the Dodd-Frank Act. It's about as popular and as useful as the FFIEC, and it's something which probably should just die a quiet death somewhere, and let's stop worrying about it. But I will tell you that there are certainly supporters of President Biden that were heavily involved in standing up the FSOC and would like to see it reinvigorated. And reinvigorated is probably too much of an emphasis. Making it work even partially would be a good idea. But again, I doubt very much if it's going to happen, because agencies simply don't like to cooperate with each other. And in the same way that there's very little cooperation under the FFIEC, FSOC probably, again, should just go away. We put in here resolution of the GSE conservatorships and point out that this is something that will be coming. In the Trump administration, there was actually talk of having an IPO and selling the U.S. government's interest in the GSEs, which could probably bring in somewhere between $800 billion and $1 trillion, which could then be used for infrastructure. However, the consumer advocates are maybe dead set upon trying to keep the GSEs as public utilities, making loans. And what is the golden ticket for them is maintain at all costs the affordable housing mandate that is in the GSE Acts, which have always been very, very problematic for the GSEs in order to be able to conduct their operations. But again, a number of proposals which will probably begin to filter out, and we'll see how the conversation goes. Now, before we finish up, I want to talk a little bit about business as usual. And I mentioned a moment ago that Dodd-Frank was not fixed when it should have been about 3 years after it was originally adopted. And eventually in 2018, the Economic Growth, Regulatory Relief, and Consumer Protection Act was adopted, which gave the Federal Reserve and the FDIC and others the ability to tailor rules with respecting U.S. banks, depending upon your size and your complexity. And there was an emerging reality that very few banks are really systemically important. In fact, only one FDI insured bank has ever failed with assets more than $60 billion. And in that case of the one that did fail, which was WAMU, the FDIC suffered no loss. So there's really still an issue out there. At what level is a bank too big to fail? We're now up to $250 billion, but it also the act also gives the regulatory agencies the ability to further tailor rules regarding capital plans, stress tests, and so forth. And frankly, it's worked very, very well. If there's any one thing we can say is that it has worked well. And what you may see is a change in emphasis, but not an elimination of those rules. And you see some of them up here as well, loss absorbing capacity. The Volcker rule, to this day, I still can't figure out why they've got it. But again, it has been, many banks have been exempted from it. And it is, again, another rule that might want to be revisited, but it's become the holy grail of some people and will continue on. We've got a few moments left, and I'm going to turn it back to Tom to give some observations and conclusions.
Thanks, Joe. Joe really nailed it when he was talking about the Financial Stability Oversight Council, that on the one hand, the council's activities appear to be of no consequence to many financial institutions, or to extreme consequence to the financial institutions that were designated for supervision by the Federal Reserve. I think the other dimension, building on Joe's observations, that very few of the agencies will wish to enter into coordinating routines and to adopt rules or practices that are designed to look across the boundaries and to regulate activities that cut across regulatory frameworks, is the simple fact that the Federal Reserve simply shows no appetite to supervise very large non-bank financial institutions. And that might prove to be difficult with some of the appointees to the agencies who really do want the Financial Stability Oversight Council to work, because preserving all of the levers to guard against episodes of crisis is an important element to financial regulation from their perspectives. I think the other observation that we could make, which won't surprise anyone, is that the process to adopt new rules will take time. Proposing a new regulation itself takes months and months, mostly because the cultural practice is to conduct outreach among various industry groups, regulated financial institutions, and consumer advocates to ascertain what the standards should be, what the problems are, and what the likely costs are to any new rules that could be adopted. That whole process, plus the process of wading through and evaluating the comments that are submitted, will take months for development. And so, just as we've seen with the agency's actions under the Trump years, that many of the rules were adopted in 2019, 2020, we shouldn't be surprised if new rules for the officials in the Obama administration are adopted in 2 or 3 years.
As we've mentioned several times, the Biden administration has indicated it intends to view regulation through the prism of discrimination and the elimination of racism. We don't want to, we're not overemphasizing the fact that this is going to be a real concern, which we're going to have to be looking at. We're going to have to be looking at disparate impact analysis, and the appointees at the Department of Justice and Civil Rights Division, as well as over at the CFPB. We didn't have time to talk about the fact that they will probably have another reorganization. Director Mulvaney's reorganization back then stripped away a lot of the power of the office that engaged in disparate impact analysis at the CFPB. So I think that's really got to be a priority for a lot of banks. And we're just about out of time, but Tom, do you just want to say a few words about some areas where we're just unclear as to what the answers will be?
Sure. We've got big developments in financial services for fintech companies, as well as the initiative for the OCC to provide new charter, new form of supervision for the type of fintech that is providing central bank services, but is not going to be a fully formed national bank. That initiative already is underway, and unclear how the incoming controller will either accelerate or pause on that process. And then, of course, cutting across financial services, but high in the minds of supervisory agencies, is what to do about cryptocurrency and coins. For incoming Chairman Gensler, this area will not be a surprise, but for the activities of the CFTC and the SEC, I think this is going to be a headline item for those agencies.
we are now going to turn it back over to Nick.
Hey, well, thank you, Joe and Tom, for that interesting presentation, and to our audience, thank you for your attendance and your attention. Please remember to sign in on the attendance sheet and return it to attendance@dorsey.com. If you have questions for our speakers, there were none in the queue, but feel free to contact them using the contact information provided in the materials, or get in touch with your usual Dorsey relationship contact. Our next meeting of the Roundtable is planned for Thursday, March 25th, just 3 weeks from now. So look out for your invitation for that as well. And with that, we are concluded. Thank you.